And that finding was a finding that of a contravention that the Conflict of Interest Act had been broken by Mr.
Section
Trudeau.
9 of the Conflict of Interest Act.
And I'll start with Mr. von Finkelstein. Do you believe that the RCMP, particularly related to criminal matters, should have access to cabinet confidence documents in order to adequately provide oversight?
Justin Trudeau, when pressed by reporters at some event in Canada, looked Canadians right in the eye and said the Globe story was false. He lied to Canadians. He ultimately received your report, Mr. Dion. He says, well, he disagrees with some of the findings. He accepts the report and takes responsibility for the mistakes that he made, whatever that means.
So could having more evidence, understanding what the bigger context is, and certainly you don't know what you don't know, but if there was more information available, could that have influenced and led to you, the RCMP, and others coming to a different conclusion? Mr. Dion?
This guy's garage. Like and subscribe.
I'm going to start with you, Mr. Dion. Thank you for joining us today, sir. My question is, of course, about the Trudeau 2 report. How many people did you interview, and how many people made submissions to you?
I have, at the end of the report on the last page, Michael is finding the page. If I recall correctly, we had 22 people we contacted for documents, and we interviewed 7 out of memory.
So of the 22 you interviewed, 7, would those 7 have been then the top of your list? Is that how you'd characterize that?
It's in the public domain, Mr. Chair. So we did interview former Minister Morneau, former Minister Wilson-Raybould, Mathieu Bouchard was a senior advisor to the PM, Nathalie Drouin, Deputy Minister of Justice, Elder Marquez, senior advisor to the PM, and Michael Warnick, who was with you 2 days ago. The other people with whom we communicated we were satisfied that the documents they had forwarded were sufficient for us to understand their participation in the subject matter without having to interview them.
So Mr. Warnick said that you personally interviewed him, that's correct?
Yes.
Is that true for the other 6 people?
Yes, it is. Throughout my tenure, I was present. Every time anybody was interviewed, I was present. This was Madame Dawson's practice as well. I simply followed the same practice.
How many investigators, did you have that worked on the file?
We had 1 investigator, and we had 1 lawyer, Michael, who is here today, who played an extended role on this one, because Madame Richard was excluded from the file right on day 1. I gave clear instructions that Martine Richard was not to be involved in this investigation. So it was Marie-Josée Smith, Michael Aquilino, and I, period.
Is Ms. Smith still employed in the office? She is. You've said that in interviews following your retirement, sir, that your investigator has a set, or that you in the process used 49 questions. Is that the right number? It was a list of 49 questions?
I'm sorry, Mr. Chair, I have no recollection whatsoever. I don't know. We don't know. I have no idea where this comes from. I don't.
Okay. If I recall correctly, I think it was in a podcast where you talked about your interview process, maybe with the Hill Times.
It's not possible, Mr. Chair, because we don't have a standard interview format.
Okay.
Each time, the way it works, each time we have a witness, Marie-Josée prepares a draft, Michael reviews it, I review it, and we follow the script, except that the commissioner is there to add, to emphasize certain things, to ask questions that come up because of earlier answers and so on and so forth. Okay. So there's no preordained format whatsoever.
In the case of the Trudeau 2 report, were you fully able to discharge your investigatory duties defined or provided for by the Act?
No, as I said so in the report, Mr. Chairman, we tried to obtain further documents that were covered by the Cabinet Confidences Convention, and we failed in doing so. So therefore, but I thought that we had nevertheless enough material to come to a conclusion, to a finding. That's why I did proceed absent the documents that were missing, that we still don't know what they contain.
Right. And that finding was a finding that of a contravention that the Conflict of Interest Act had been broken by Mr.
Section
Trudeau.
9 of the Conflict of Interest Act there was a contravention, as we refer to them, to Section 9 of the Act, which was the scope of the investigation. I decided on my own volition, in light of the media and what was being said elsewhere, to launch an investigation on February 8, 2019. The scope was Section 9,
Okay.
and I did find a contravention to Section 9.
Thank you very much, sir. Commissioner, are you investigating any board members at Sustainable Development Technologies Canada?
Talking to me?
Yes, sir.
I'm sorry. I thought you were still dealing with
I just
my-
changed gears.
Can you
with
repeat your question, please?
With my last minute, a couple quick questions for you. Are you investigating any board members at Sustainable Development Technologies Canada?
Yes.
How many?
2.
And have you launched any investigations of your own accord, or only files that have been referred to you?
No, I have only launched investigation at the request of I think members of parliament or maybe the public, I don't know, but not on my own.
Have you interviewed relevant people in those cases at this point?
Mario explained to you the process, and that's exactly what we're following to, where we decide who has to be interviewed. We make a set of questions. The questions are being posed by the investigator. I'm there, I'm present. I may ask additional question or clarification if required.
So I have two quick questions in my last 15
Very
seconds.
quick.
Have you received access to all of the documents that you've requested? And when can Parliament expect a return on those reports, sir?
Yes, I have received all the documents I've asked for. We are interviewing a few more witnesses, and then as soon as we can, we'll issue a report. Obviously, I'm fully aware that time is of the essence. These things shouldn't drag out too long, both for the public but also for the person being investigated.
Yes, sir.
So we will do it with due dispatch.
Thank you, sir.
I'm trying to, for me at the crux of this, and one of the things I've been really stuck with is the Convention of Cabinet Confidence and the issue of the position of the government, particularly this government, I would say, that being both the client and the solicitor, that they have, basically that client solicitor privilege, and then the broader stroke of cabinet confidence as a convention. And I'm wondering to the members, and they can each answer, their thoughts on the effectiveness of that, and whether or not for issues that require greater scrutiny, third, nonpartisan oversight, that through their offices, having access to some of those key documents and information would help provide a better check and balance to the PMO or the Privy Council.
The Act is quite clear. We have access to those documents if we require them and we need them. Obviously, in each case, if there is a refusal to give some or part of documents, we look at and are they essential to the investigations or not. If they are, we will push it to the ultimate, and as Mario mentioned, we can always go to the federal court if we think it's so germane and so central to an issue but most of the time, you work this out, you understand there's some reluctance, you make sure you get the documents that you need in order to reach your decision. Your decision being, was there a breach of a conflict of interest or not? And that's in the past has always been worked out, and I'm pretty sure it will be in the future. That being said, the law is quite clear. If we need access to these documents, we can get it. Mario, you want to add something?
I will just add that's precisely what I did. I did assess whether, with the documents and the refusal to provide further documents, I had enough to proceed, and I concluded I did. And there were several instances during my 5 years where Michael and other lawyers who work at the office were able to gain access to cabinet confidences in a very practical, informal way. This was actually the first time that we were opposed with a written no. You will not gain access to additional documents.
As it relates,
the problem with cabinet confidences is that you don't know what you don't have. So you have no idea what you're not seeing. And but I determined I had enough to do Section 9, so I proceeded.
And I think, like, for me, in listening to the testimony of the RCMP, and when I hear things that, investigations cannot proceed based on the information that is available, do you believe, and I'll start with Mr. von Finkelstein, do you believe that the RCMP, particularly related to criminal matters, should have access to cabinet confidence documents in order to adequately provide oversight?
I think you should put that question to the RCMP rather than me.
Okay.
Or, to see
if you don't want to answer,
they feel they have enough. Obviously, nobody should be able to hide behind criminal acts, and the investigators should have access to all the facts necessary to determine whether a crime has been committed or not.
Thank you. Stories were posted this morning about additional information as it relates to the Prime Minister's trip to Jamaica. And in particular, I note the way in which the information is coming out in trickles, dribs and drabs. First, there's a bit of a denial, and then there's a bit of a deflection, and then there's a dig in, and then we find that there's more and more information. So, in light of the various Trudeau reports, and in light of some of these discrepancies, do you believe that amendments to the Conflict of Interest Act should provide, particularly, to the office holders and to the Prime Minister, what do you suggest that we do to tighten that up so that the perception of a conflict and the real conflict are dealt with in a seriousness that helps kind of restore the public confidence and trust?
You used the word perception right now, and I think it's very important to do that. Unfortunately, the Act deals with conflict of interest. There is no apparent or conflict of interest provision. There is in the code for the members of Parliament, as you know, for House of Commons, as you know. That's a question that you could put in. That is not only a real conflict, but a perception of or apparent conflict of interest. Another one, since you're talking about the Jamaica trip, is, for instance, should there be a ceiling on gifts? Right now there's a complete exception for gifts from a friend. You could say, well, that's fine, but, if the gift is too large, it may create the wrong appearance, and maybe we should have a monetary limit on it.
I really deeply appreciate that, because I know that, there was a past commentary that, well, if they're wealthy, why shouldn't wealthy people be able to give wealthy gifts? But I think to the average person watching, the average person struggling in this economy, that extravagant gifts in the tens of thousands of dollars, $80,000 plus in these luxury settings, it begs back to my earlier points about sponsored travel and other things, that in a time with conspiracy theories and distrust in government, that there needs to be that cap. So I'm glad to hear that reflected in the testimony today. Thank you. Those are my questions.
Okay, thank you, Mr. Green. That concludes our first round of questioning. We've got 5-minute rounds followed by 2.5. And just a reminder to the committee, I do want to leave some time because Mr. Villemure wants to bring up an issue in front of the committee that should not take too much time. Mr. Brock, for 5 minutes, go ahead.
Thank you, Chair. And thank you to the witnesses for your attendance today on this important study. I'm going to read to you a portion of a mandate letter that Justin Trudeau supplied to one of his ministers, Minister Anand. Talked about raising the bar on openness, effectiveness, and transparency in government. Says it also means humility and continuing to acknowledge mistakes when we make them. Canadians do not expect us to be perfect. They expect us to be diligent, honest, open, and sincere in our efforts to serve the public interest. Yet February 7, 2019, the Globe and Mail cites unnamed sources, reports that Justin Trudeau and his aides attempted to pressure Jody Wilson-Raybould while she was AG to intervene in the prosecution of SNC, and that exasperation and her lack of cooperation was one reason for shuffling her out of the justice portfolio. Justin Trudeau, when pressed by reporters at some event in Canada, looked Canadians right in the eye and said the Globe story was false. He lied to Canadians. He ultimately received your report, Mr. Dion. He says, well, he disagrees with some of the findings. He accepts the report and takes responsibility for the mistakes that he made, whatever that means. He didn't elaborate. We all know your conclusions. Your conclusions were well-founded. Your conclusions were based on all the evidence that you received. You took it upon yourself, I believe, Mr. Dion, to identify all the relevant witnesses and the evidence that you hoped to be able to discharge your responsibility. Is that correct? And I've totaled 14 individuals that you ultimately either interviewed or received by way of affidavit or some other written documentation. I contrast that to the RCMP. And I can't express how profoundly disappointed I am as a member of Parliament, but as a former officer of the court and a former Crown attorney, of the shipshod way that they conducted this investigation. They only interviewed Jody Wilson-Raybould twice. They interviewed Jessica Prince, her chief of staff. They interviewed Natalie Drouin, Deputy Attorney General, and nobody else. And when I asked the commissioner not too long ago, why didn't he actually seek out some information from the Prime Minister himself, the person of interest? They didn't think that they had sufficient grounds to do that. That really disturbs me, sir. I'm not going to be asking you about RCMP decisions, but what I am going to ask you about is when you interviewed Justin Trudeau, was he forthright with you? Did you get the impression he was giving you all the information that you requested? Was he holding anything back?
So I recall the interview vividly. It was long, over 2 hours. Prime Minister was accompanied by a few lawyers. And he did respond to every question we asked. There was no feeling of resistance or trying to indirectly avoid questions. He did provide answers to every question that we had.
Okay. Your standard of referral to the police, I believe you said, is on reasonable grounds. Is that a reasonable ground test? And perhaps to Mr. Is it Aquilino? Is it the same reasonable ground test that law enforcement uses in terms of laying a charge?
I believe so, yes.
Okay. So, and again to Michael and to you, Mr. Dion, we all know that there's two elements to any criminal offense, the actus reus, the mens reus. The actus reus is the act of the pressure exerted, either by Justin Trudeau himself or his aides. The mens rea requires a specific intent. Now, I want to circle back to your report, Mr. Dion, paragraph 284. I'm going to read it out to you. It's very, very, very brief. Here, in contrast, the evidence abundantly shows that Mr. Trudeau knowingly, the operative word, knowingly, emphasis mine, sought to influence Ms. Wilson-Raybould both directly and through the actions of the agents. That's the operative term I look for as a former Crown attorney. So I'd like to know your opinion, perhaps Mr. Aquilino, in terms of the reasonable ground test. Did that not give you the ability to make that referral based on that finding?
I think that those are legal issues. The criminal side, the Conflict of Interest Act, knowingly in the context does not necessarily mean knowingly for the mens rea purposes under the criminal code. That's a legal issue. So
well, I disagree respectfully. I think it knowingly means the same thing. It's an intentional act to do something knowingly, as opposed to innocently, accidentally. Knowingly is purposeful.
Sorry. You're gonna have another opportunity to ask questions if you like. Mr. Housefather, go ahead, please.
Thank you very much, Mr. Chair. Gentlemen, thank you for being here today. Mr. Dion, I have a question for you, a little bit of an esoteric one. In Section 9 of the Act, it reads, no public office holder should use his or her position as a public office holder to seek to influence the decision of another person, clear, so as to further the public office holder's private interest, clear, that makes all kinds of sense, or those of the public office holders' relatives or friends, makes lots of sense. But then it goes on to add, or to improperly further another person, gets you another question.
But maybe they didn't understand.
This is not an issue.
I did with Mr.
Whether or not that threshold was.
Because there is a myriad of possible scenarios. It's always dangerous to try to put an exhaustive list of situations. That's why I think with the flexible approach, No, until I did the answer.
We're going to go 4 and 4. I'd already predetermined that in advance of Mr. Green speaking. Mr. Kirk and then Mr. Baines for 4 minutes. On va donner un peu de temps pour M. Villemure à la fin.
We'll allow some time for Mr. Villemure at the end of the session.
Thanks very much, and appreciate the testimony here today. Mr. Aquilino, Mr. Brock had asked a question about the Prime Minister having, quote, knowingly influenced former Justice Minister and Attorney General Jody Wilson-Raybould, and that term knowingly. And it's my understanding that in civil and criminal law, it's a fairly low threshold, but it is interpreted the same. And I'm just wanting, if I could, Mr. Aquilino, your interpretation of that threshold and whether or not that threshold was in fact met, and your interpretation of the events that took place related to that question around him having knowingly influenced.
Sure. So when you apply the facts of what transpired here to the wording of the offense, so 139 sub 2, you have to apply the knowingly standard to the act of obstructing, perverting, or defeating the course of justice. And what the case law says that it takes more than a mere moral lapse or an ethical lapse of judgment. It takes something, an additional step, so a corrupt intent, a criminal intent. And this is where we had difficulty in establishing that intent.
So when it comes to the establishment of that intent, at the time, and I was not elected at the time when I followed this, both the breaking story in the Globe and Mail and what transpired, the damning testimony that Jody Wilson-Raybould had brought forward at committee, and just the whole, it was extraordinary to watch. I was very troubled at the time how narrow the constraints were on the evidence that could be obtained both by the office of the ethics commissioner, but also in light of that to the Justice Committee and presumably the impacts that had in relation to the RCMP being able to get to the bottom of exactly what you've referred to about knowing what that intent is. So could having more evidence, understanding what the bigger context is, and certainly you don't know what you don't know, but if there was more information available, could that have influenced and led to you, the RCMP, and others coming to a different conclusion? Mr. Dion?
Purely speculative. So it's impossible to answer your question. Of course it could, or maybe it couldn't. I don't know.
So it could have, and I think that's the question. Why were the constraints so tight? And certainly that's an outstanding question that remains, and an incredible disappointment that there was not a willingness for the government to be more transparent, and it leads one to ask the question about what is there to hide. Now, I do want to ask another question, because yesterday the Liberals tabled a amendment to the Canada Elections Act. And in that, on page 2, there's a very interesting change to the election date. And as the public, I'm sure, is very aware, MPs qualify for a pension after 6 years of service. The election was planned to be held on October 20th of 2025. That would have been 1 day short for MPs elected in 2019 to qualify for their pension. And while Conservatives are calling for an election immediately, I'm just wondering if that delay in the page 2 of this act, if that would be a conflict of interest for MPs to basically vote on something that would be the difference between them either qualifying or not qualifying for their pension.
Very, very quick response on that, please. Very quick.
You as MPs have the power, make the rules for yourself, including your code of conduct, and also when elections are held, etc. That's not a conflict of interest. It's something that you are charged. It's a duty one would expect you do it in the public interest and not in your personal interest.
Thank you.
But that's
Would there be a
That's enough time.
Could there be a perceived conflict in that?
No, Mr. Kirk, I'm sorry. I'm over time. I think the commissioner answered the question. Go ahead, Mr. Baines, 4 minutes.
Nefariousness and perhaps conspiracy theories going down that rabbit hole, but October 20th of 2025 is the day of Diwali, which many hundreds of thousands of Hindu Canadians celebrate. So I think it's good for us to be. Sorry, Mr. Brock, are you interrupting my time here? Oh, okay. I'm glad that you are. Thank you so much. So just wanted to clarify that and put that on the record.